This is Michael Popok, Legal AF. We've got a new ruling by the D.C. Court of Appeals that spells trouble for Donald Trump and any effort by him to take his D.C. election interference case out of D.C. and change venue. New York is too liberal. He can't get a fair trial there. I think this new case in the D.C. Court of Appeals, 3-judge panel, including 2 Trump appointee judges, 3-0, ruling that Thomas Webster, a former New York City police officer who brutally beat a D.C. cop as he stormed the Capitol on Jan 6th, in his appeal, which primarily focused on, I can't get a fair trial in this town. This is a Democratic town. There's too many Democrats. They can't be fair and impartial. Shot down by the 3-judge panel. Written by Judge Millett. Judge Millett, you may recall, was also the judge who wrote at least one of the gag order decisions approving primarily of the gag order that Judge Chutkan had put in place on Donald Trump. That's been the template for the other gag orders used in other places, like in New York by Judge Merchan. It was that strong, that watertight, that airproof, airtight and waterproof, sorry. So that Judge Millett, very well respected. She'd be on the short list for the United States Supreme Court when Joe Biden gets another opportunity to appoint people to the United States Supreme Court. Like if somebody, dies, or Sam Alito is impeached and removed, or Justice Roberts does the right thing and resigns, like that. But let me go back to the decision. Webster argued primarily in his appeal, he had some other grounds on the appeal, but his primary purpose of the appeal was to argue to the D.C. Court of Appeals that he couldn't get a fair shake, that the jury pool was the voter pool, for instance, which is not completely the jury pool. They don't pull from the voting records. They pull from usually Department of Motor Vehicle or other types of registration. So there's not a one-to-one correlation between political affinity and the jury pool. But even if you were to point to it, he said, whoa, the voters, 95% of the voters voted for Biden in the District of Columbia, and only 5% voted for Trump. I can't get a fair trial. It's all Democrats. First of all, let me be clear. Under your 6th Amendment right under the Constitution, nobody has the right to a trial of their hand-selected peers and colleagues of their party. You don't get to look out if you're MAGA and see a sea of 12 or 9 MAGA hats. Yay, that's not the jury of your peers. The jury of your peers are people who are adults in your community that have been called for their civic duty. And the process by which juries are selected, which is what this 3-judge panel just ruled, ensures that fair and impartial jurors are selected. It is the process. Trust the process. It is the process by vetting, by what we call voir dire, by interrogating and interviewing each potential juror using the challenge, the peremptory challenges, which each side has to bounce a juror for no good reason, as long as it's not a bad reason, and the for cause use of that process, voir dire, the questioning of jurors, their responses, which you have to take at face value and in good faith, unless you have counter evidence to say that they're lying, which occasionally happens, as the in this adversarial process, the prosecution or the defense in a criminal case do their background research, go hunting through social media, go look at photographs on Instagram, and like, whoa, look at this one. Even a Democrat can be fair and impartial in a MAGA case. Even a MAGA can be fair and impartial if they go through this vetting process. That's what Judge Millett said. And so they rejected using a long line of Supreme Court precedent, and now making new precedent in the District of Columbia Circuit Court, which has a lot of weight, not just for all the trial judges below the DC Circuit Court, because it's the intermediary appellate court right before the United States Supreme Court for everything in the District of Columbia, which means Judge Chutkan and all the trial level judges, there's about 20 of them in Washington, have to follow what their bosses just said in a 3-judge decision, 3-0. Now, if there's what's called a request for an en banc decision, then the entire panel has to vote. All of the appellate judges have to vote. There has to be a majority to even want to hear the case en banc and then make a decision. Almost all, except for a small subset of appellate cases, are resolved by 3-judge panels at the federal level. And that's it. And that is the law. That then you can say the appellate court has spoken. The DC Court of Appeals ruled that. Okay. And that's what we have here. And in this one, the appellate court that now all courts below it have to follow. And it has a lot of precedential value or a lot of persuasive value because the DC Court of Appeals is considered to be a very elite gig, a very elite court. And other courts look to it, almost like a junior Supreme Court. Many of the DC Circuit Court judges and DC Court of Appeals judges end up going to the United States Supreme Court. Ketanji Brown Jackson, Merrick Garland, who was picked but not ultimately confirmed as a Supreme Court justice, came out of the DC Court of Appeals. Very influential, not just in DC. Even state courts will point to the DC Court of Appeals decision if they can't find a Supreme Court decision on point. This is what Judge Millett said for the majority, not even the majority, for the unanimous decision of the 3-judge panel, including Naomi Rayo, Trump appointee, and Greg Katsas, big-time Trump appointee, and Millett, who was appointed not by Biden, but by somebody else. Have you heard that the flavored air category is quickly becoming the leading alternative to vaping and smoking? It's a whole new movement towards better habits, led by the sponsor of today's video, Fume. Fume is an award-winning flavored air device, and flavored air isn't like vaping. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. Fume has lots of delicious flavors to choose from, like crisp mint and orange vanilla. With flavored air, you can satisfy your oral fixation through a passive diffusion system that utilizes no electronics, vapor, or combustion. Instead, Fume draws flavor to your mouth. Fume fills the void ditching a bad habit can leave. There's no vapor, and you can use it anywhere. There's no nicotine, and it's not addictive. The non-toxic flavors are a guilt-free alternative. Fume doesn't use any batteries, so you'll never need to charge it. The design is super sleek, it looks awesome, and you can truly feel the weighted, high-quality design. I mean, one of the fun things about Fume is that it's made to fidget with and calms anxiety with magnets, snaps, and clicks. Fume continuously invests in third-party studies to ensure the safety of their products. My favorite Fume flavor is the orange vanilla. It's just as delicious as it sounds. And look, if you're trying to kick your bad habit, I couldn't recommend Fume enough. Fume has served over 300,000 customers, and you can be the next success story. For a limited time, use my code LEGALAF to get a free gift with your Journey Pack. Head to tryfume.com. That's TRYFUM.com and use code LEGALAF or scan the QR code on the screen to get a free gift with your order today. We expect jurors, this is a quote from the case, to view significant criminal events in their hometown with an unapproving eye, whether it is the Jan 6th attack on the Capitol, a murder, or an armed robbery spree. Generalized disapproval of criminal conduct, even the specific conduct at issue in a defendant's case, says nothing about a juror's ability to be impartial in deciding whether a particular individual committed a crime or not. Again, you don't get a perfect trial out of your Sixth Amendment rights. You just get a fair and impartial one. The judges concluded that even if jurors who were critical of Trump during the selection process, the voir dire jury selection process, were not, that does not mean that there was evidence of unfair prejudice to the defendant. Where, in other words, what is the evidence? You can't just point, that's a Democrat, they don't like Trump, they voted. That's not enough. You need evidence to show that despite all of that, they can't be fair and impartial. Again, a MAGA Republican, if properly vetted, is assumed to be fair and impartial under our law, as is the leftist of left-wing Democrats. The judge went on, Judge Millett went on. Nothing in those jurors' statements suggests that they had prejudged Webster's guilt, the guy that beat up the cop, who was a former cop, or even incapable of deciding the case objectively based on the evidence. And without that, you get no change of venue. Why does it matter to Trump? Because Trump's been arguing almost an identical thing, because they all take pages out of the same playbook, up in New York, and which he thinks he already made a motion for venue change, and it was denied by Judge Merchan, and it was denied by his appellate bosses at the Appellate Division First Department. But it will be a Court of Appeals, highest level of New York issue when or if he's convicted. And he'll argue that. And then the appellate courts will be able to cite back to the DC Court of Appeals in Webster versus US and say that's not a Sixth Amendment violation, neither under the New York Constitution or under the US Constitution, because there's no evidence that these people couldn't be fair and impartial or weren't fair and impartial as they served on the jury. This will kill Donald Trump's future motion or future appeals ground on change of venue. I couldn't get a fair shot in New York. My case should have been tried where all the Republicans reside, which is Staten Island. That's the argument. That got shot down by the Appellate Division First Department, by Judge Merchan. And now with this new support, persuasive support will be shot down, I believe, by the appellate court at the highest level in New York, the Court of Appeals. This is like a twofer. This also allows Judge Chutkan, if and when she ever gets the DC election interference case back in her wheelhouse, back in her trial court, from the United States Supreme Court, making a ruling filing that we're waiting on immunity, she'll be able to deny the inevitable motion to change venue by Donald Trump, citing to this case of Webster. That's why I wanted to bring it to your attention now, have you start chewing on it, start understanding it, have it be a prism through which you evaluate all of these tactical decisions by Trump and others on Jan 6th. We just had a sentencing. Of, I'm not making this up, Sedition Panda. He wore a giant panda head. His name was Jesse James Rumson. His lawyer, who's a lawyer for a lot of MAGA, he actually told Judge Nichols, you can't get a fair trial in this town. There hasn't been a fair January 6th trial yet. And that was a bench trial. So he's basically accusing the judge, Judge Nichols, of not giving his client a fair trial. He didn't even bother with a jury trial because he knew he'd never get a jury not to convict his client or to exonerate his client. But this has been the drumbeat of the MAGA and the MAGA lawyers. Can't get a fair trial. DC's very liberal. Can't get a fair trial. And the DC Court of Appeals has put a stop to that now. Sure, could Webster try to take an appeal to the United States Supreme Court? He can try. He can try. And we'll see what their result is going to be. First stop is Chief Justice Roberts. He'll have to decide whether to decide on that issue or send it over to the panel and see if there's 4 votes to grant the writ of certiorari and bring it up to the appellate court, and 5 votes to change the district of the DC Court of Appeals ruling. I mean, they've done it before. They've done it before. On the immunity decision, for instance, it looks like they're going to change what a 3-judge panel did related to that, led by Judge Pan, P-A-N, another justice. So it can happen. And especially when you have MAGA right-wing like Alito flying insurrectionist flags at all of his homes and trying to blame his wife for running it up the flagpole to see who would salute. So we'll have to keep an eye on the Webster case, just like we're keeping an eye on the Fisher case to see if in the last gasp of decisions that come out of the United States Supreme Court in the next few days, literally, we see them find that the use of obstruction of an official proceeding, one of the highest charges that the prosecutors used by the Department of Justice against Jan 6th insurrectionists and Donald Trump, was appropriately applied or not, or overcharged. We're waiting on that decision. That came out of Judge Nichols also, through to the Supreme Court. And we'll have to follow all of it right here. And if you want to follow all of these gyrations and all of these developments at the intersection of law and politics, the intersection of law, politics, and the Constitution of the Supreme Court, you've come to the right place. MeidasTouch, Legal AF. Join us Wednesdays and Saturdays at 8 p.m. Eastern Time for a podcast. Yes, we named it Legal AF for a reason 4 years ago. I know why. You will too when you join us. We curate the top 5 stories at the intersection of law and politics. We bring it to you right here, 8 p.m. Eastern Time. If you want to watch it, if you want to listen to it, we're on every major podcast platform. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.